Okay, we have a great set of speakers lined up for you today. Our moderator is Doug Melamed, who is currently a scholar in residence at Stanford Law School. From 2015 through August 2022, Doug was a professor of the practice at Stanford Law School with a focus on antitrust law and intellectual property. Before joining Stanford, Doug spent 5 years as senior vice president and general counsel of Intel Corporation. Prior to joining Intel, he was a partner in the Washington, D.C. office of Wilmer Hale, where he served as chair of the Antitrust and Competition Practice Group. From 1996 to 2001, Doug served in the U.S. Department of Justice as acting assistant attorney general in charge of the Antitrust Division, and before that, as principal deputy assistant attorney general. Welcome, Doug. I will turn it over to you to introduce the other speakers.
Thank you, Kristen. So the topic today is how do we make sense of what's going on in Washington in terms of antitrust enforcement, and a lot of rhetoric and a lot of talk about changing standards. To discuss this, we have three very experienced people who bring very different perspectives on this problem. Renata Hess is a partner in the DC office of Sullivan Cromwell and co-head of the firm's antitrust group. She joined the firm after more than 15 years in government, including leading the antitrust division at the Justice Department twice as acting assistant attorney general. Mike Wyatt is a managing director at Morgan Stanley and head of the global technology mergers and acquisitions there. He is a Stanford MBA and has advised on literally hundreds of transactions, especially in the technology sector. And Diana Moss has been president since 2015 of the American Antitrust Institute, which is a public interest organization dedicated to research and advocacy for sound antitrust law and policy. She's a PhD economist and is a member of the adjunct faculty of the Department of Economics at the University of Colorado at Boulder. So, the Biden administration has seemed to give antitrust enforcement and policy to the progressive wing of the Democratic Party. The FTC chair, Lina Khan, has been one of the leading and most outspoken of the so-called new Brandeisians, who have criticized both previous administrations for under-enforcement of the antitrust laws and the conceptual underpinnings of modern antitrust law, in particular the so-called consumer welfare standard. Jonathan Kanter, who heads the antitrust division of the Justice Department, had a more traditional background as an antitrust partner in big law, but more recently opened his own boutique focused on helping the little guy. That's my shorthand. Since Khan and Kanter took office, the agencies have retracted guidelines and guidance letters, made statements about new policy objectives, revised their merger procedures, and brought enforcement actions with mixed success. So let me begin with Renata, who's closest, I think, to the front lines of antitrust enforcement. As a factual or descriptive matter, Renata, what's new about antitrust enforcement in the Biden administration that corporations and their boards ought to be aware of?
Thanks, Doug, and it's great to be here and to be speaking with all of my co-panelists here. So, I mean, I think I was trying to decide whether to start with the bad news or the good news, depending on which perspective you have on these questions. I mean, the messaging is clearly more aggressive, I think, and is designed to really chill mostly M&A activity. And I think, you know, as enforcers, we always go out and tell people, don't violate the antitrust laws, and if you do bad things, we will come get you. This has been, I think, more anti-business in feeling than prior administrations. There have been a bunch of process changes, which can impact the timing on transactions and can impact certainty. You know, and I think we're going to talk about some of this in the merger context. And the agencies are exploring, I think, new theories of harm and thinking about bringing cases that push the envelope in areas where they feel the law has been weak. So vertical mergers is one where we're, I think, likely to see more activity. We have seen a little bit more activity. There have been whispers of conglomerate effects, I think, meaning just companies are effectively getting too big, which is a theory that Europe employs, but the US traditionally hasn't. We've seen a big focus on labor and employment. That started at the end of the Obama administration when I was running the antitrust division. Criminalization of Section 2, that's something that people haven't seen for decades. And we've just seen the second of 2 indictments in that space. But I think, so there's a lot going on that makes the environment feel very different. As a practitioner, there's just a little less transparency with the staff. You get a little less information from the staff throughout the process, which makes it harder to advise your clients about exactly what's going on. But in the end, I think good arguments, good substantive arguments are still prevailing. Transactions that don't threaten harm to competition are still getting done, and they're getting done in 30 to 60 days as opposed to longer than that. So I think there's just been a lot that's been designed to make people worry a lot particularly about deals that have hair on them. But the general outlook for a transaction when you're advising a company or advising a board, I think really hasn't changed that much in terms of the ultimate outcome.
Mike, is that how you see it?
Well, I think you hit a couple of important themes. Maybe I'll give it from the business perspective, mostly from the perspective of companies that are seeking to pursue mergers or acquisitions that they think are good for their business, good for their shareholders. I think the general sentiment of anti-business feeling is I would say that is a consistent feeling, more opposition to mergers. And I would say that in general, the business objectives would be wanting to do more. The enforcement creates restrictions on that. Part of the friction and frustration, I think, is maybe hits on your point about transparency, which is knowing in advance what the outcomes are going to be as much as you can with as much clarity so that you don't pursue something that gets rejected. If you know it's going to get rejected, then okay, you can move on to the next thing. It's the things that look like they're going to be okay, but then get dragged out and you get surprised. That, I think, is another frustration point. And you have to kind of get deep into the administration and decisions to really see what practice is going to be different, particularly when the implementation, as you said, has changed. And so, businesses want to pursue these mergers. They want to be big. They want to be successful. They want to be profitable. Sometimes that's at odds with policy. It is increasingly at odds with policy. And your point about just being big is an issue. So big tech is kind of squarely and it feels like it is squarely in the sights of the administration policies. And so we feel that amongst our client base who are looking to us for advice about, can a deal get done? What are the business impacts? And then can we enter into an agreement where we properly allocate the risks if a transaction ultimately gets blocked? And how do we resolve that with our counterparties?
But Diana, you're probably looking at this more in a policy sense than in terms of the clients. Renata said, there's been a lot of saber rattling, but not all that much has changed. Mike is concerned, among other things, about lack of predictability and transparency. How does it look to you?
Yeah, thanks, Doug. And you're right. I'll take a run at this question from a pretty different angle. And just to set the context, we are where we are right now after, I'd say, good 4 decades of pretty weak antitrust enforcement and merger enforcement in particular. So for the Biden enforcers to come in on a pretty aggressive, ambitious agenda to strengthen enforcement across the board and with a focus on the merger control program, that's going to take more than 2 years to reverse 40 years of damage. And the courts work slowly, the wheels of justice turn slowly. and so the Biden enforcers are in a tough spot, reversing long-term trends, changing the case law, but in a very short period of time. And so, we have some data points on case outcomes, but we don't have enough data at this stage in the Biden enforcers' tenure to really be able to connect those outcomes back to how they might shape enforcement in this big feedback loop, and to shape competition policy. So, when you're in a situation like that, I think it is incumbent upon the agencies to really create a strong focus, a clear focus, and a framework. And that framework consists of guidance, case selection, messaging to the business community and the bigger community at large, soliciting ideas and learning through workshops. I mean, we haven't seen much of that, but also to reiterate what Mike and Renata said, transparency is really critically important. So I think what we're seeing obviously is an ambitious agenda, but we're getting a mixed. We're in the middle of some smoke here. We're waiting for the smoke to clear to identify trends. So the business community is really in a position where they're having to gauge their reactions to what the agencies are doing or not doing. And my concern is this, that the business community can absolutely begin to exploit some of the lack of transparency in what's going on. So for example, in the United Healthcare Change Healthcare case, also the sugar case and other cases, we could probably expect to see more cases that exploit those types of losses, right? Why not leverage, if you're in the business community, why not leverage off of the losses that the agencies have sustained? We're likely to see more workarounds to the more aggressive agenda on things like litigating the fix, right? If DOJ is unwilling to talk about remedies up front, then that forces the parties into court with their fixes. And I don't think we want more litigating the fix in the courts. I would even put the Kroger-Albertsons dividend problem, which is really gun jumping, right? It's an economic form of gun jumping. I would put that into a category of the business community really taking on the FTC and the ability of the FTC to address an action that would really debilitate a competitor and influence the analysis of the merger. No updated workload statistics, no HSR report for 2021. That's all a lack of transparency for the business community. And I think, as Renata mentioned, potentially a loss of staff engagement with the business community, and also, by the way, the advocacy community. So all in all, I think there are some of this may create some really troubling incentives for the business community to exploit some of the gaps in the current agenda.
Can I just jump in on one thing, Doug? Sorry, I always have to feel like I have to defend the part of the antitrust enforcement of the last 20 years or so that I've been in it and that you were, Doug. And that is to say, which is without at all trying to claim that it's been perfect. I don't think it's been wholly ineffective, or that there are clearly some matters that people like to point to, airlines, ticketing, that where they think the agencies might have settled a case that they shouldn't have settled. But in terms of the track record of the agencies challenging transactions that were likely to cause harm, I don't think it was that terrible. So to me, the conversation shouldn't really be about, well, we've had 40 years of terrible and antitrust and useless antitrust enforcement, and we now need to break the entire system and then rebuild it. It really should be more, and here I'm agreeing with Diana, it should be more focused on where are the places where we think competition has been harmed because we haven't had the right tools, either in the case law or in statutes, to deal with it. And let's try to focus on those and fix them. And what I don't like about the current environment is that there's this very broad brush, anything that anybody wants to do, representing any kind of client, but I mean, mostly if you're engaged in representing technology companies, well, you're just trying to do something that's bad for the economy and bad for consumers, as opposed to really thinking about and focusing on finding good cases where consumers really are going to be harmed, and bringing cases that you can win so that you can change the law. And to Diana's point, there's been a lot of language about, well, we don't mind losing cases because we want to bring hard cases, but losing cases has real costs to it, both in the creation of the law and also in terms of the morale of the people who are working very hard for less pay than they would make at law firms. So sorry for the defense of the prior regime, but I do think it's important to think about the issues in less of a broad brush way.
Doug, can I just respond to Renata really quickly? Just point of clarification. What I said was not a condemnation of 40 years of antitrust enforcement. I think I characterized it as weak. And we can point to certain areas of antitrust enforcement that had an outside impact on the weakening effect. And say vertical mergers, right? Live Nation Ticketmaster is now the poster child of failed vertical merger policy, right? We haven't had that many Section 2 cases, definitely an under enforced area of the law. During the Obama administration, we actually saw some of the strongest merger enforcement we've ever seen in terms of, settling more cases by seeking injunctions versus settling them with remedies. And we've been, as a progressive organization, we've been trying to flip that. So just to clarify, there have been areas of enforcement that have suffered more than others. But the reason why I raise this is because for organizations like AAI, which are centrist, slightly left of center organizations, our ideology is to strengthen and support and invigorate enforcement largely within the existing framework. And yes, we will need legislative support to do that. It is far separated from the neo-Brandeisian approach, which we see as the basis for the current set of enforcers.
Well, let me try to bring this back a little bit from the policy issues, about which I'm sure we all have lots of views. The question is suggested in effect by the last sentence of what Diana said, which is, okay, the new Brandeisians, broadly speaking, seem to be in the cockpit right now. And what does that mean in the practical matter in the near future? So let me focus on mergers first, because that's been obviously from the comments that people have made, it's most on people's minds, and they probably raise concerns of the most immediate interest to corporate directors and the most immediate impact on market structure. So the agencies have talked about new policies, including new guidelines, especially regarding vertical mergers, more skepticism about merger remedies short of simply blocking the deal, increased focus on transactions involving private equity, and concern about the impact of mergers on workers. A survey of practitioners that some of the folks here might have seen that was, I think, put on SSRN recently and reported about this morning in Global Competition Review, reports to find that merger control in the perception of these practitioners has become more opaque and combative under the Biden administration than in the prior years, particularly at the FTC. So I have really three questions, because I'm going to add to what I was going to ask a question that's in the Q&A from one of the viewers or listeners, and they are this: have the agency's enforcement actions they've taken reflected their claimed new priorities in their rhetoric? Second, what guidance can you give corporations about the direction and policy soundness of merger enforcement in the Biden administration, insofar as it departs from past practice? And third, and this is the one from the Q&A, I'll read it to you. As a lay business person, I'd love to understand more about the criteria and process for determining whether a merger or acquisition harms consumers because of less competition. I don't think we want to spend the next half hour, on a tutorial on merger analysis, but I think it might be useful for anyone, the three of you commenting on this set of questions to sort of frame the issue and what basically have we previously thought merger analysis to be about, and is there anything new in the Biden administration? But anyhow, who wants to take a stab at some or all of those three questions? Mike, why don't you?
Well, I want to hit on maybe the last point in terms of harm to consumers as the endpoint of an analysis of what are the impacts of this merger. I want to kind of hit tech in particular, because I think tech has a little different flavor than a lot of the other traditional industries that we've talked about. And tech is where this is the most active sector for mergers and acquisitions and consolidation. Understanding technology and the technology impacts is hard. If you're not really a deep expert, it's easy to misforecast what's going to be the impact, particularly when technology companies are choke points or platforms for extending or building an industry. The impacts can be very broad. And I think it's hard for regulators or anybody who's not deep in the industry to see the impacts. Either things that are particularly strong or things that look like they're harmful, but really aren't going to be a big impact. There's a lot more opportunity for innovation and disruption in technology. That's been the history of technology. So while there have been some particularly powerful towers of technology, they're mostly because people imagined and built great products, and they're better than the competition. And so they're out ahead. And when you think about all of the benefits to consumers from basic Google search, for example, a magical feature that we all take for granted now, but it was imagined and developed and built. So I think there's a tech overlay that makes it tough. That's not really the kind of the policy question you started with at the end, but I do think in terms of this analysis around impacts to constituencies, it's harder in some industries than it is in others, airlines or manufacturing or grocery, that are more about, finite set of resources and how much capital is put in a concentrated market. It's a different analysis there than it is in other places. So it's hard for folks who aren't in the industry to really get that right.
So let me just jump in on and I'll try to answer the question in the Q&A quickly. Although, as Doug said, one could spend a lot of time answering it. I mean, the goal that the agencies have, and have traditionally have, and I think still have, is to examine whether or not the two firms that are engaged in a transaction either are competing directly or have the capability, once merged, to harm competition. And the first is a horizontal merger, the second, roughly speaking, is a vertical merger. And they do that by going through, what could be a short or a long process of seeking input from the marketplace, from all kinds of people, getting data and documents, working with the parties, talking to the parties, looking at the parties' documents, and about a transaction. And they really do try, I think, and I think they're generally good at figuring out, what's people who are trying to get a business advantage or take advantage of the merger process to harm competition, actually, as opposed to promote competition, versus those who are customers or consumers who actually believe that the transaction would result in harm. But ultimately, the job of the agencies, in my view, is to make sure that transactions don't move forward if they will result in an increase in market power, and that means an increase that would harm consumers, either higher prices, less innovation, less research and development, less output, things like that. And to me, that the question actually sort of tees up what I think the key debate is currently, and what I think the key debate should be currently, and that is whether or not the average amount of antitrust enforcement, merger enforcement in particular, that has happened in the US is the right amount. Have we done too much or too little? And I think part of what you're seeing in the uncertainty and unpredictability in the current administration is driven by the sense that maybe these things that people used to look at, like price, output, innovation, research and development, aren't the full package of things that people are looking at now today. So they're looking at employment and the impact on laborers, not just in terms of wages, but even we've gotten questions in the merger process about whether or not the target or the buyer has organized labor, and what would happen to that after the transaction. These are more, some of these questions, not all of them, but some of them are more in the nature of kind of, government planning, policy planning questions, and, seem less focused on competition. And I think that's the real question that we're trying to answer, is what exactly is it that's driving some of these decisions? Is it in a kind of economic planning, or is it really competition and a competition issue? So I'm personally in favor of people thinking hard about new ways of addressing competitive harms. And the tech industry is a perfect example of a place where people have felt for a long time like these small transactions that don't appear to result in, the Meta Instagram, Meta WhatsApp case that's going on with the FTC right now is a perfect example of this, where the FTC looked at those transactions however many years ago and thought they were fine. And now people today think, well, maybe they weren't okay. So how do you attack a transaction where there's some nascent competition that might be extinguished? How do you do that? That's one of the hardest things for the antitrust laws, I think, to deal with in today's world. And that comes up a lot in the tech space. So I don't know if that was helpful, but I'm trying to accomplish a bunch of different things all at once.
And Diana, before you jump in, maybe just to kind of add, Renata, to your point on, what I'll call Facebook, Instagram, Facebook, WhatsApp back in the day, it's impossible to know what the alternative scenario would have been for what would have happened to those companies or products if they had stayed independent. Would they have been as successful? They're obviously, globally very successful products, and you can't rerun the A/B test for these unique, truly unique assets. It's a good example of why I think the job of being a regulator is really hard when trying to judge the impacts of, an action or a non-action.
Yeah, just to dovetail on what Renata and Mike have said, I'd just like to add some different perspectives. So the question in the chat went originally to, or in the Q&A went originally to effects of harmful mergers on consumers. And as Renata very accurately pointed out, under the consumer welfare standard, adverse effects of consolidation and conduct absolutely can be felt in the input markets, including in the labor markets. And that is, labor market effects have really not been addressed very closely, if at all, for some time. And I think one thing the Biden enforcers should get credit for is really opening up labor as a really central topic for antitrust. So the win, DOJ's win in Penguin, Simon and Schuster, is, I think that's a landmark case. DOJ prevailed in positing a theory of harm in a labor market, and got a very strong opinion that look, that's the end of it. Anti-competitive effect in the labor market, harm to authors, and depression of compensation to authors in terms of advances. And you don't need to see an effect in an output market, downstream in the book market where consumers are hanging around. That is a landmark decision. And so I think it sets the mark. Interestingly, if you look carefully at some of the FTC's cases, they are really addressing non-competes. and the harm that is delivered to labor through non-compete clauses. They are requiring removal of non-compete clauses. And so there's there's stuff going on in the background over at the FTC on labor as well. So that's labor. That's a big new shiny area for antitrust. And the Biden enforcers should get some credit for doing that. On the consumer side, I just want to add that we're seeing more and more forays into non-price effects of mergers on the consumer side. So, all the economic research and tools and methodologies really go to price effects, static price effects of mergers, higher prices post-merger because of the elimination of competition. But because of changes in business models and technological advancement and other economic developments, the effects that consumers feel are not always price effects. They could easily be quality effects, right? A lower quality experience, say in a digital platform, that means that your data is not looked after and it is potentially abused and used because it is central to the value proposition of a digital platform. Same thing with innovation. We're seeing the agencies bring more innovation cases, how mergers harm innovation. We haven't seen many lately. We'd like to see more of those. So price and non-price effects on the consumer side are really important. And a lot of this is being driven by, the development of sort of the business ecosystem, which is a highly integrated, horizontally and vertically integrated business organism. And in the digital spaces, those ecosystems pose really novel questions for law and economics and the application of the antitrust laws because of their complexity and all their unique economic features like data externalities and tipping effects, and I could go on and on. So I think a lot of this is really important to consider in what we see driving the agenda at DOJ and the FTC.
I asked a couple of other questions about merger review that are really, I'm going to mention some comments, criticisms observers and participants have made in recent months, and then ask the three of you to comment. One is that a lot of the participants in the merger process say that traditional antitrust problems, the kind of thing that might have things that might have provoked at least a serious investigation and maybe a merger challenge, are being overlooked at the agency, particularly the FTC. And one theory, of course, is they have a different agenda in mind, and they're not prioritizing traditional competitive concerns. And that, I guess, is related to what Diana was saying when you talked, I think, quite rightly about the need for rigorous economic analysis of new theories, new business models, and new market structures and the challenges that they pose for an economically focused competition law. But the question arises, I guess, do the cops on the beat really care about economically focused competition law, or do they have something else in mind? So that's one question. And the other question is whether the agencies have adopted a lot of procedural rules, changes, no early termination, broadened investigations, threats of post-merger reviews, not so much to guard against, to enable them to bring legal challenges to problematic mergers, but rather to make the merger process so burdensome that they can deter companies from bringing as many mergers forward as they otherwise would. I'm wondering whether the three of you think that there's anything to those two sets of criticisms.
I'll defer on the agenda point, but on your last question, is it deterring mergers being brought forward? I feel like definitely yes. There's definitely, in effect, there's more caution in boardrooms around whether or not the transaction is going to get approved. So there are things, deals that might have happened where the risk of failure, regardless of the agenda, means that they just get set aside and they don't get pursued. In a world, maybe a previous administration where there was more confidence, then those transactions would have, more likely been brought forward. So that's definitely, it's palpable in the, what I'll call the business decision makers world.
Mike, let me just ask you a variation of that question. I understand that if you think a deal that you would have been optimistic about no longer looks to have as good prospects, you might abandon it. Are you finding that companies are not pursuing or are abandoning deals, not because they think that at the end of the day they won't get it passed, after litigation or whatever, but because they think the process has become so much more burdensome and time consuming that tips the balance, and they're saying, I'm not going to spend 2 years getting this merger cleared. It's just not worth it to me.
Yeah, it's some of both. It's a complex calculus that goes into the decision to go ahead and pursue, and things like the prospect of having to litigate to consummate the merger. It's very unappealing. It feels like bad press for the underlying businesses, particularly where if it's if the customers are enterprise customers who read the press and are going to feel impacted. It could be harmful to the underlying businesses, and your business can erode while you're in this pendency period, particularly if you're the target business in the merger. If you don't successfully consummate the deal on the back end, you've kind of been hung out to dry for whatever period of time. So you have to deal with a scenario where you've agreed to sell, you fail, you probably have a big impact to your team and your customers. And so the prospect of that outcome on the back end is daunting and definitely a deterrent.
So Doug, I might say something a little heretical, but on this topic. I mean, I do think that sellers are using the uncertainty around the agency process and the potential lengthiness of the process to try to extract very significant concessions in the risk allocation clauses in their agreements. And I think some of that, honestly, is being manufactured by lawyers who wish to demonstrate to their clients that they're tough and that they can get these kinds of clauses in their agreements. So we're definitely seeing, people demanding, for example, not only a hell or high water clause, but a way above market reverse break fee, and a commitment to litigate everything you could imagine under the sun that a buyer could do. And that's not something that many buyers are willing to sign up for, even if there is no risk in the transaction. So there is a little bit of a I don't know what the right word is, but a kind of gamesmanship going on even amongst the practitioners. My own view is that a deal that doesn't raise issues is going to get done, right? And telling the agencies that you're going to do a divestiture or enter into behavioral remedy when you don't think that there's actually a behavioral remedy or a divestiture that would solve any problem that you can imagine, assuming you have competent antitrust counsel, it doesn't really make a lot of sense, because you're suggesting to the agencies that there's a problem that could be solved when there isn't one. So in that case, then you get drawn into this point that Mike just issued, which is, then the best guarantee you can give as a buyer is to say, I will litigate this. If they're unreasonable, I will make it clear to them that I'll take them to court. And then the seller says, well, I don't want to litigate. I mean, why would I want to do that? So it's a very, it's turned into this kind of crazy dance, all coming out of this idea that the agencies are going to do something kind of insane with a transaction that doesn't raise any issues. And my own feeling about this is that we all need to calm down a little bit, because transactions that don't raise issues are getting done. They're getting done in 30 days, even big ones. So, if you really don't, sometimes you don't have issues, but there's something to explain, then you need a little bit more time. But, deals that don't raise issues are getting done. And people, I think, do need to relax a little bit when they're thinking about these things.
And when you say don't raise issues, you mean don't raise the kinds of issues that you would have recognized when you were at the antitrust division as legitimate, serious antitrust issues? Or
Yeah,
are you
but I
talking
also,
about,
when
issues in the eyes of an eccentric new Brandisian?
Well, so here's your predictability problem, right? So I can try to imagine all kinds of harms, and when we're counseling clients, that's what we're doing. We're trying to figure out what are the whole array of things that somebody could raise, whether they're traditional, kinds of problems that are familiar to me, or problems that are maybe less traditional, and then gaming those out. And how serious are they? And if they're, if they come up with a crazy problem, is there a solution to those? So we try to cover.
But here's what I mean by that. I think my question wasn't clear. I understand you want to think creatively about economic harms, new theories, new industries, new transactions. But there you're still dealing with, I guess to use some jargon, the consumer welfare standard mode of analysis. Are you facing a situation where the agencies feel that there's a real issue that you think no industrial organization economist would be worried about, but they're worried about because it disadvantages labor, it disadvantages franchisees for reasons having nothing to do with competition in the market as a whole?
Well, I mean, I think you have to say, okay, you might get sued on that issue, whereas you wouldn't have gotten sued on that before, but your defenses are good.
But you're going to win. Okay.
It's the difference between stricter rules that are known and stricter rules where there's a wide band of the outcome. It's that uncertainty that I think is a real challenge for folks.
Can I just come in here with again some different perspective based on the work that we do and how we view the bigger antitrust infrastructure. I think it's a good idea to ask of the current enforcers, hypothetically, what is the end game here, right? They have a very limited amount of time potentially, which might be dictated by political outcomes and outcomes in the courts and a lot of other exogenous factors. They have a limited amount of time to implement a very ambitious agenda. And so when you're in that situation, messaging becomes critically important. And so let's ask, well, what are the agencies messaging out? Well, they've clearly messaged out that they're going to bring more cases, and they're going to bring cases on newer, more ambitious theories of harm. So for example, the meta within case is a good example of that. I think the Microsoft Activision case, when we see a complaint, might well turn out to fit into that category as well. So new cases and more ambitious cases, and the agencies are willing to take their chances in court and win some and lose some. Second, at least on the DOJ side, messaging that we're closing off avenues for settlement, right? We're gonna seek more injunctions and potentially force you into federal court to litigate your remedies, which I've already said is not a great outcome. Third, let's just sound tough, right? Let's just be tough. We're gonna sound tough. We're gonna take our time with second reviews. And we're gonna sound tough so that we stand a better chance of winning in court, right? This is all about balancing litigation risk. And then fourth, let's have some new guidelines. Let's retract old guidelines. Let's issue new guidelines. And that will help the business community understand how we expect to go about evaluating merger transactions and potentially merger remedies. So that's all part of a messaging campaign or a messaging approach. So, and that's absolutely got to follow in a strategic way a more ambitious program of enforcement. My question is this: if this does not happen, if we are at the end of 4 years and we don't see the same enforcers carrying on for longer terms, then we're at a pivot point, another inflection point where new New guidelines could be retracted, much like the Section 2 guidelines were retracted or policy statement was retracted earlier on. You know, a lot of the progress and a lot of the momentum and movement that the Biden enforcers are trying to achieve could well be dismantled or even reversed. And so the question is, if the Biden enforcers get to the point where they see some sort of end point and they're successful or on balance not successful, whatever, they can always say, well, look, we tried really hard. We tried really hard to invigorate antitrust enforcement and we didn't succeed. And so we need new laws. We just need new laws in the United States. So that is a discrete potential outcome. I don't think Congress would be willing to step up with new laws based on what we've seen in the last couple of years. But by having an eye on sort of the end game and how the messaging accompanies sort of the more ambitious agenda, I think we absolutely should be thinking ahead to 2 years to see what we're going to be dealing with depending on the different outcomes.
Okay, I'm going to leave the question for the very end for everybody to comment on, you know, what's the legacy going to be of this administration, looking, you know, speculating about going forward. What I want to do now in the few minutes that remain is to go back to a couple of other topics that we haven't gotten to and that are suggested by questions in the Q&A. So, for example, we haven't talked yet specifically about the Sherman Act. We focus mostly on mergers. The Sherman Act, as certainly all the panelists know, is more broadly concerned with a wide range of conduct beyond mergers that might injure competition. Both agencies have talked about being more aggressive with respect to enforcing the Sherman Act with respect to labor markets. The Justice Department has said it's willing to bring more criminal cases, not just for the hardcore offenses, but to a wider range of violations. That raises the question of what's really changed under the Biden administration. And a question in the Q&A from the audience asked about divestiture. Is divestiture in tech or media in the cards? Interesting comment. Maybe some would disagree. Nobody seems dissatisfied with the AT&T breakup in the 80s. I'm not sure any of us on this panel do, but I can't speak for everybody. Anyhow, anything new in the Sherman Act, and should we anticipate any not only criminal cases, but maybe big cases seeking divestiture remedies?
Divestiture in mergers or under?
No. Well, I think the
like
question
a breakup, like the Microsoft breakup.
Yeah, something like that. I think that's really more what the question had in mind. And obviously, you can comment on either one if you want. Without.
Yeah, I mean, so I doubt it. I doubt that we'll see a Sherman Act divestiture case, partly because I think we're running out of time. As Diana said, you know, we're 2 years in, and the Microsoft case moved very fast, but most Section 2 cases don't move that fast, particularly today. So we know there are ongoing Section 2 investigations in the agencies right now. Whether those will come out with a divestiture remedy, I suppose it's possible, but I think it's pretty unlikely. That's at least my.
Do you advise your clients to be more cautious in areas that might be subject to Sherman Act review now than in prior administrations, or do you think not much has really changed except maybe in the labor market?
So I generally think that people are looking for Section 2 vehicles because, as Diana noted, there's been a relative lack of Section 2 enforcement in the days since you were at DOJ, Doug. So I think that, the reason why I'm sort of hesitating, Doug, is that I think I always tell people to be careful about Section 2 because I think Section 2 can be a real problem. Do I think it's more likely for there to be some enforcement today than during the other prior administrations? Marginally. But, one of the things that we haven't touched on is that both agencies are incredibly busy and really trying to do, a million different things at once. And so those investigations, Section 2 investigations, are very time intensive. So
Let's turn to an aspect of the FTC that we haven't talked about, Section 5 of the Federal Trade Commission Act. Unlike the Justice Department, the FTC is structured as an independent agency. It has 5 commissioners, its own rules, its own system of administrative adjudication, in which it has a remarkably successful record. Since Lina Khan became chair, the Democratic majority has adopted a number of policy and procedural changes, issued a new statement regarding the scope of unfair methods of competition under Section 5, as extending beyond the Sherman Act. Rulemaking under that section is, I guess, anticipated. And at the same time, we have, of course, the Axon case pending in the Supreme Court, which, although specifically focused on a narrow procedural issue, could foreshadow some important restrictions on independent agencies like the FTC. What's happening with respect to Section 5? What can we expect here? Is the commission going to give it a significant meaning beyond the Sherman Act that will survive judicial review, or is this just a lot of talk?
So
Well, no, go ahead, Renata.
I was just going to say something quickly. I think one thing that we will likely see is that Section 8 of the Clayton Act, overlapping directorates, there are some gaps, one could say, in Section 8. Applies only to corporations, not to LLCs, at least arguably. There's always been a discussion about whether Section 5 would capture Section 8. Conduct, interlocking directorates that don't satisfy the statute, Section 8 statute. I think we will see that for sure. Whether we see something bigger, I'll leave to Diana.
Do you think that, this is to all of you, not just to you, do you think that the talk and the rhetoric surrounding Section 5 is going to have a kind of ripple effect on the Sherman Act, either at the agencies or in the courts, in terms of the way they construe the Sherman Act? Maybe Diana, you can kind of address both questions if you.
Sure. Yeah, that second one's a tough one. So we read the Section 5 statement. We have to now go back and take out our microscopes and really do the deeper dive. But I was surprised at how little attention it got in the press. We get phone calls all the time as a public interest group, and did not get very many questions on Section 5. So the Section 5 statement. So I think that is interesting in itself. I think the statement, I think it's very well written. It's strong. It's very well written on its face. But I do think it's designed to set up a very broad framework for what types of conduct would be considered reachable under Section 5, many forms which have not been previously entertained or even thought about or mentioned. And because it's that broad, I think maybe the approach is, well, let's start broad and then we'll see what it gets whittled down to, right? Once it sustains challenges and scrutiny and debate and that sort of thing. So a few things. There are themes that come out. One is obviously the incipiency standard. There's a lot of talk about M&A and conduct that ripens. They use the term ripens into violations. So also reference to serial acquisitions and what I call creeping concentration as potentially reachable under Section 5. There's this focus on incipiency. There's focus on a whole array or menu, as Renata was just pointing out, of types of conduct that go beyond competition on the merits, but then must be shown to negatively impact competition. And that extends to, the intersection of intellectual property law and competition law. It extends to misuse of regulatory processes, for example, a coercive conduct, abusive conduct. I mean, this is very broad. It's extremely broad. And so whenever something is that broad, I think the expectation is once it gets through the process, what will be left in terms of conduct that can be reachable under Section 5 under this incarnation.
Let me end by looking forward to where we were a minute ago. We've heard a lot of comments about the agency's not acting procedurally entirely transparent way, and some people would say undermining the rule of law. With respect to law, so far at least, they haven't obtained any important new legal precedents, and as you commented, courts are probably pretty conservative about those things these days. They have not promulgated or even published for comment any new formal rules. The administration hasn't gotten new antitrust legislation enacted. The agencies will probably adopt new guidelines, but those can be repealed by later administrations. It's early, but we are, I guess, halfway through the Biden administration. What do you, and it's for all three of you, what do you expect will be the legacy of the progressive leadership of the antitrust agencies in the Biden administration? Will it have an enduring impact on anything other than the mergers and other conduct that get reviewed during the time it was in office?
I'll go first. Mine is simple. I think the legacy has already started, which is deals that wanted to happen that didn't happen. And a lot of that you don't see in the public domain, but we see them being discussed and passed on. And so, and I think the ones that are the most interesting are ones that feel like they would have, could have, should have under previous administrations, but the risk of an adverse outcome blocked people from getting there. And in technology, things that seem like they're exciting, that would be additive, get passed on because there's too much uncertainty at the moment.
So I'm going to give Diana the last word because I think she's going to have the best answer, the most interesting answer. I think there are two things. So one is I think there's going to be the look back will say there were missed opportunities to do things and to expand the law to reach tough areas. I would say mostly in Section 2. I think a positive is that I do think a lot of the language, maybe anti-business, has been empowering to consumers in a way that I think has been a positive. Consumers and workers, to say that you can expect something from your government and we can do something to help you. Now, whether they deliver on those results, remains to be seen. But I think some of that language has actually been a good thing.
And then last word.
Yeah, so I think the major impact is, I would agree with Mike, is going to be in the merger program. That's where I think we see most of the risks being taken in bringing new cases, different theories of harm, how the agencies procedurally are willing to deal with the parties. I think the outsized impact within the merger program is obviously going to be in the digital area, which is lines up with a commitment of the Biden enforcers to go in and go hard on the digital sector, given all of the concerns around the market power of the big digital players. But hey, AAI has done a lot of research saying that it's not just those players that need attention, it's all the up and coming digital players that are acquiring their way to greatness, like Salesforce and Intuit and others. At the same time, we may get very mixed merger law outcomes on digital, which I think is going to be important because the digital business ecosystems, as I said earlier, are very different, and the economic incentives and mechanisms for amassing and exercising market power are just very different in digital ecosystems. So that could end up being a bit muddled. At the same time, I'm going to say that I don't think we're getting anything novel or better out of Section 1, which we think at AAI is a critically important area of enforcement. Concentration in certain sectors is extremely high, with just 2 to 3 major players. So tight oligopolies and domestic cartels are absolutely real, and we're just not seeing a commensurate ramping up of enforcement in Section 1, particularly information exchanges, which, by the way, fit into this digital arena. And on Section 2, yes, we've seen some cases brought in the last couple of years. Those are digital cases. And so where are the monopolization cases in agricultural biotechnology, for example, Monsanto's and genetic traits and other monopolies. How about Zillow in online? Well, that's digital too. See, I just trapped myself, but we're seeing a lot of dominant firms emerge, but we're not seeing enforcement attention given to those firms. So maybe the outcome is, lots of attention on digital. That's not to say the agencies aren't bringing other cases in more traditional sectors, and those are to be noticed and acknowledged. But if that's what we have at the end of this regime, that I think that in itself raises a lot of questions about the goal of strengthening and modernizing antitrust enforcement as a whole, as it applies to all areas of the law and all sectors.